Good morning, counsel.
Thank you, Your Honor. My name is Tom Reed. I represent Joule Incorporated, a New Jersey corporation, its Boston office, and 3 individuals who have been complained of by Randy Simmonds for violating both Title VII and Chapter 151B of our laws. The question presented in this case is, in essence, does Simmonds need to arbitrate her discrimination dispute?
Well, that's maybe part of the question, but isn't there another question about whether the MCAD is bound by what she needs to do or doesn't need to do?
Your Honor, I believe the MCAD is plainly not bound by what Ms. Simmonds does need to do under her private agreement to arbitrate discrimination claims with Joule.
But I mean, in other words, isn't part of the question whether the MCAD, whatever may be true about Ms. Simmonds' ability to bring a case under Section 9 of 151B herself to the Superior Court, and there is an issue about that, but putting that aside, isn't there an issue about whether the MCAD could proceed and grant relief that would be victim-specific?
I believe, Your Honor, there is no issue about that, and the law, I believe, is unequivocal that the MCAD can grant victim-specific relief to Simmonds.
And
Yes.
what happens if that relief is inconsistent with the decision of the arbitrator? Which controls?
Your Honor, I'd say that could be either an ordinary or very complex question in former adjudication, and I believe that the case emphasized by Simmonds, EEOC versus Waffle House, raises but does not answer those detailed issues. So,
Well, isn't that a reason then for saying that the MCAD cannot, it may have every right to investigate and make awards, but not as to this victim, because this victim might get relief that is different from what the MCAD would order?
yes.
And you would have 2 inconsistent rulings in the same case.
That's possible, Your Honor, and that possibility is left open in Waffle House, and I would say correctly so. And I would say on behalf of Joule, this Court shouldn't rule, to put it fancily, in the subjunctive. That is, were these certain circumstances to occur, then, and offer a complete and full roadmap to former adjudication, the rules of res judicata, and double recovery. I believe EEOC does answer, in part, the questions presented here, even though the case is differently focused.
You mean Waffle House?
Waffle House.
And Waffle House has a different agreement than we have here. It has the type of agreement that we had in Warfield, which is very different. It has a general arbitration clause that doesn't even mention discrimination cases.
That's correct, and the dissent in Warfield emphasizes that the clear and unmistakable requirement to arbitrate a dispute concerning arbitration may run afoul of the supremacy clause. In EEOC, to be sure, EEOC versus Waffle House, thank you, Justice Bosford, for forcing me to say the full name. In that case, the employer asked the district court to enjoin proceedings of the EEOC in the United States District Court, and the district court declined. And you're right, Your Honor, Justice Cowan, the dispute triggering clause in that case was any dispute arising in the employment agreement, and it held, as do a panoply of Supreme Court cases, that pre-employment dispute resolution clauses are enforceable. The arbitration could go forward, but the EEOC's suit was unimpaired because it is the public agency's province to determine whether it wishes to expend public funds to recover damages. And it goes without saying, the Supreme Court emphasized that a private arbitration clause cannot bind non-parties, much less can it bind a public enforcement agency. But it did say that Baker, that was the name of the gentleman in the EEOC versus Waffle House case, his conduct may limit the relief awarded. That is, even if the EEOC seeks victim-specific relief, if Mr. Baker has already obtained it in his arbitration, and I emphasize that the court is crystal clear that the arbitration Mr. Baker has agreed to goes forward under EEOC versus Waffle House. That's clearly stated in the opinion and clearly stated in footnote 9.
So it would be somewhat a race to conclusion. Are you suggesting that if the arbitration concluded first, then that would prevail, that award would prevail, or if EEOC concluded first, that would prevail?
I think, Your Honor, it goes back to my answer that these questions get very complicated. So let me give.
But it's something we have to think about if we're going to say that that she is entitled to a victim-specific award. But let me ask you a question. I just want to be sure I understood you. Your position is that the MCAD would have every right to go forward.
It is.
Okay.
I would want to offer a detailed explanation of how it goes forward, but yes, Your Honor. So if the MCAD goes forward and orders injunctive relief
with a
against
Section
Joule,
5 proceeding.
correct, orders an administrative fine of $50,000, orders victim-specific relief of $20,000 made up of front pay and back pay. However, there's been an arbitration as required under the private arbitration agreement before the AAA, and the AAA has awarded $20,000 of front pay and back pay. I believe Joule would be privileged to argue that it didn't have to pay that recovery twice, that that would be double recovery. But I do not believe Joule, on those simple facts as I've stated them, could make any argument that the Commission was not entitled to order injunctive relief.
All right, but the relief you're seeking here is that the MCAD action be dismissed.
That is not the way I would put it, Justice Cordy.
I'm just reading your brief. Oh, well, you say requiring Simmonds to dismiss her MCAD action.
So let me answer that question with more precision maybe than I succeeded in my brief. First, this dispute is governed by the Federal Arbitration Act, Section 2, not by the Massachusetts Act. The Federal Act allows no balancing of a state preference for a state administrative agency decision maker and the mandate of FAA Section 2 that any dispute be referred to arbitration when the parties so agree. That balancing does occur in Supreme Court cases like 14 Penn Plaza, where the court asks, did the National Labor Relations Act, as contemplated by Congress, allow a carve-out from the FAA? But that's not a question this court can ask under the Massachusetts Arbitration Act, nor can this court balance Chapter 151B or other state laws proposing decisions in administrative agencies like Chapter 110A, our codification of the Uniform Securities Act. All of those policy preferences are foreclosed by the Federal Arbitration Act. The answer to your question, Justice Cordy, is that the specific relief requested by Simmonds here, perhaps not as clearly laid out in the brief as it should be, is simply this. And the specific relief arises under the Massachusetts Arbitration Act, which does govern the procedures in this case. That is MGL Chapter 251, Section 2. Under Section 2, Joule is entitled to an order directing the parties proceed to arbitration. That is what Joule seeks.
So you're fine with parallel proceedings?
Yes, we must be fine. That's the law.
And you're fine with Ms. Simmonds being able to file a complaint with the MCAD?
That must be true, Your Honor. Whether a petitioner calls the MCAD via telephone, meets in person, or writes a 50-page single-spaced complaint, that's not merely the petitioner's right to petition. That must be so under Chapter 2.
So your disagreement, if I understand correctly, unlike the New England Legal Foundation amicus, but your disagreement really is with the plaintiff's position that this particular arbitration clause either is unclear in certain points or in any event is a contract of adhesion.
That is our disagreement, but I'm not walking away from what NELF states in its brief, and I would say it's a fair implication of our request under Chapter 251 for an order from the Superior Court directing the parties proceed to arbitration. That is, we do ask, Justice Cordy, that the Superior Court, as part of its order Simmonds not to participate as a party or a litigant in MCAD proceedings. And that would be, Your Honor, under the Code of Massachusetts Regulations, 804 CMR 1.20, usefully attached to the Commission's brief in this case. Appears at the addendum, I believe, at page 70. After the Commissioner decides which issues to certify for a public hearing, the aggrieved party may ask to intervene in that proceeding. And we believe Simmonds should be foreclosed from asking to intervene in the proceeding. In no respect does that touch and concern the relief the commissioner seeks in the proceeding or the post-certification complaint that we'll issue. As well, we say, Your Honor, that under Section 9 of Chapter 151B, and this is part of what NELF emphasizes in its brief, Simmonds, when she goes to arbitration, would notify the MCAD she was proceeding in arbitration, and her complaint would be dismissed without prejudice. But I want to be clear, whether those two things follow. Yes?
Oh, her complaint to the MCAD would be
Yes.
dismissed without prejudice?
Without prejudice.
But
And that
then-
would have no effect on any commission proceeding. That is, the commission has received the complaint, and as MCAD points out in its forceful brief, it is in charge of the investigation, it is in charge of drafting a commission-based complaint, and it is in charge of ascertaining what relief to seek.
So if the administrative proceedings proceed, they will proceed as an MCAD complaint, as a self-initiated complaint, as opposed to a complaint of Simmonds.
Yes, Your Honor, although MCAD would say that's a distinction without a difference because all proceedings under Section 5 are commission-based proceedings on commission complaints. The only distinction I'm drawing, and it's not one this Court need reach, it can simply say in order that Simmonds proceed to arbitration. But the point I'm making is Simmonds should not be allowed under 804 CMR 1.20 to intervene in the proceeding.
You said earlier that Joule would have the privilege of only having to pay damages once. I'm curious, does it make any difference whether the MCAD awards damages greater than the arbitrator did or less than the arbitrator did? Does Joule get to pay the lower of the two in the event that there are two awards of damages, or is Joule bound by the arbitrator's decision in either case?
I think the answer to that question, Your Honor, is complex and depends on the precise details of the arbitration award. But I would only point out that shows why the arbitration clause actually poses, as the Supreme Court has noted in various cases, risk to the employer of having the employee have, quote, two bites of the apple. I believe the MCAD would have a forceful argument, and I would expect to hear it, that both awards should be paid and both collected because the award in the commission proceeding, even that award tailored for victim-specific relief, I'm confident the commission would argue, is for a public purpose. And even if it goes to Simmonds, it's different than, in some respects, the arbitration award. Joule would disagree with that. But I don't think this Court, in this case, needs to solve all the details of conflicting awards in arbitration and before the Commission. In fact, I would suggest that the Commission has behaved pragmatically in the past, and I would expect it to do so here. And there's really no functional difference, Justice Spina, between awards in arbitration and awards in court. Because after all, in Section 9 proceedings, where Ms. Simmonds would proceed in Superior Court, the Commission is just the same, even though the complaint is dismissed without prejudice, perfectly entitled to begin and bring a Commission-initiated complaint against Joule with a panoply of damages, including victim-specific damages. And these same questions arise of former adjudication and double recovery, and they're dealt with frequently by our courts, and they can be very complicated or very simple.
So are you essentially saying that you agree with the MCAD's position and that we shouldn't reach or resolve in this case the issue as to of double or inconsistent awards?
I agree that the Commission can seek victim-specific relief in its
Right.
petition. I don't agree with the Commission or with Ms. Simmonds to the extent they say the Superior Court
action
was
should be
correct
stayed.
in not. It's
But-
plain the action should not have been
But
stayed.
that's your only point of disagreement.
Yes, in fact, if you turn to the Commission.
Well, except for the nature of the arbitration clause.
You're right, Your Honor, and I'm happy to turn to that if you wish.
Yeah, if I can ask you briefly, would it be permissible for an employer to tell an employee that you must relinquish your right to a jury trial on discrimination claims or I will fire you?
After the employee is employed, that seems wrong. However,
Wasn't that this case? She was employed when she got this.
well, I don't think it's fair to whipsaw Joule, having allowed Simmonds 2 months to reflect on the arbitration agreement with the argument that, in fact, she's already employed.
No, but she, if I understand the facts correctly, put the two months aside. When it was first given to her, she was already working there. She had accepted the job.
She'd accepted the job, but
She
the
was
offer was conditioned on, and the
But that was after
arbitration
the
agreement
fact,
states.
wasn't it?
Excuse me?
Didn't she get it after the fact?
No, she showed up at work on the first day, and printed on the form was, this is essentially a pre-employment arbitration clause. These are routinely enforced. Her argument proves too much because it would make the confidentiality agreement unenforceable as well, and the non-solicit unenforceable.
But the difference is that there's no Chapter 151B providing certain rights to a jury trial. with
Doesn't
regard to
make
the
any
issue of
difference, Your Honor,
confidentiality.
I'm sorry for talking over you. I apologize.
Okay, so, but you're saying it would not be permissible for an employer to fire somebody for refusing to agree to arbitrate?
It's permissible for an employer not to agree to hire someone
But
for not agreeing to arbitrate.
try my question. Can they fire them for refusing to arbitrate?
I think so. Arbitration is a preferred method of dispute resolution. I think you can say, take Skirchok, which is a First Circuit case that deals with these issues, comes out a little differently on the facts, but I think you can say from now on, if you're not willing to arbitrate disputes you have with us, you really can't work with us. There may be factual details which make the answer very complicated, but I think you can change the terms and conditions of employment for an at-will employee, and the employee can accept or reject those conditions. You can change rate of pay. Can I address just...
Mr. Reed, I'm sorry your time is up.
Thank you, Your Honor.
Yes.
Good morning, Your Honors. May it please the Court. My name is Barbara Robb, and I represent the defendant appellee, Randy Simmonds, who, to follow up on the last question posed, unlike the employee in Warfield, was unrepresented and was not told that she'd be required as a condition of employment to sign a form contract of adhesion to arbitrate until after she had begun working, after she had turned down a full-time position, and while she was pregnant.
Well, this seems to be a factual dispute. He said that she was given it on the first day of work. You're saying after she had begun working.
That is after she had begun working. That's not a fact that's in dispute. It was
it's
when
not a
she had
condition-
She
it was
had
not a condition
accepted
of
the
employment?
job.
I'm
She
sorry.
accepted, but she hadn't begun working.
It was not presented to her before she started the job. It was presented to her after she started the job,
On the
her
first
first
day.
day of
First
work.
day. On the
first
Correct,
day.
correct, on the first day.
But was it ever discussed with her in negotiations for hiring?
It was not, and this is not a fact that's in dispute. This is not a factual dispute. As to the question of different results coming out, possibly, this is not an issue in this case, and where you need to begin is with the Federal Arbitration Act and this agreement. This agreement specifically states that it applies to disputes between private parties, Jolie and Ms. Simmonds. It cannot cover a Section 5 proceeding, which is brought by the Commission against Jolie in the public interest. As this court has
I
ruled...
think counsel has conceded that.
Yeah.
But does it limit your client in other ways? For example, in collecting an award from the MCAD, or from sort of removing the case from the MCAD and moving it to Superior Court? It does, doesn't it?
No, it does not.
It
does not.
It doesn't prevent a Section 9 proceeding?
The only thing that it prevents, and the only time that it comes into play, is if and when Ms. Simmonds pursues her Section 9 rights by filing in court. Then if there is an enforceable arbitration agreement, which there is not one here, then it comes into play. While she's at the MCAD, it is a Section 5 proceeding,
Right.
which as this court has ruled on numerous occasions, including in the Stonehill case, and as the legislature has spoken, that is a proceeding brought in the name of the commission in the public interest. That is the government bringing a proceeding in the public interest on behalf of, in its power as the sovereign, on behalf of all citizens in the Commonwealth.
But
Mr. Reed says that, but he says, but she cannot intervene because she signed the arbitration agreement.
We would not be intervening in this case, and as the Stonehill.
You would not be because of reasons of strategy, or not be because the arbitration agreement prohibits it?
assuming it's valid, just assuming for argument, I know you don't think it is, but assuming for argument, under Justice Gantz's scenario, would you be intervening? Would you be trying to intervene in the MCAD proceeding?
We would not. As Stonehill has said, the MCAD was established to enforce the Commonwealth anti-discrimination laws. The complainant may be a party to a Section 5 proceeding and may present testimony at a public hearing, but it is the MCAD and not the complainant that prosecutes the discrimination claim.
What do you say about the footnote, footnote 13 in the Warfield case, which says, I'm quoting, an agreement to arbitrate employment discrimination claims represents a limited waiver of rights under Chapter 151B. An employee who agrees to arbitrate such a claim, of course, does not forgo the substantive rights afforded by the statute, but does give up the substantial right to seek administrative or judicial remedies. So this Warfield says that a person who has signed one of these agreements gives up the substantial right to seek administrative remedies.
I would say that that issue was not before the court in Warfield. It was a Section 9 case in Warfield. And therefore, that position is inconsistent with Stonehill, as well as United States Supreme Court precedent in EEOC versus Waffle House.
Well, is the verb seek in the footnote that Justice Cowan just read to you one of the controlling principle? You're giving up the right to seek the remedy, but that doesn't foreclose MCAD from awarding a remedy.
You're precluding the right to pursue a claim in court, a private claim in court.
Well, no one here is disputing that the MCAD can proceed under Section 5, but the issue is whether your client has given up the right, as the footnote that I just read in Warfield suggests that she's given up her administrative remedies.
Well,
unless you can argue this was an adhesion contract or otherwise unenforceable.
Well, I can argue that, and that's a separate argument, and we have argued that in our briefs as well as.
So if you would, could you turn to that?
Absolutely, Your Honor. The provisions are unenforceable as to Section 9 rights and remedies because it's not a clear and unmistakable waiver under Warfield of Section 9 rights and remedies. It violates public policy and is unconscionable and unfair in the circumstances. The setting here was infected with unfair surprise and undue pressure. There was unfair surprise in both that arbitration would even be required and what it would entail. Buried within the myriad of applicable rules, the location of which was not provided to her, she would have to arbitrate at Jolie's offices. She would not be able to join with other women who were also subjected to disparate treatment.
Those aren't raised in this case that she wants to join with anybody else, and they waive the location of the arbitration.
That is, in this case, she and other women were subjected to disparate treatment. So it could very well be that during the MCAD investigation, they talked to other women who also want to join. That is a possibility in this case, Your Honor. There's also...
But it doesn't prevent the MCAD from dealing with these other women. It simply prevents her.
But that does prevent the MCAD from dealing with these other women because she's prevented from participating and cooperating
She's
fully.
Not prevented from... She can cooperate. She can be a witness. She simply can't get a double relief as far as what I'm hearing
but
from...
This agreement does not even apply to a Section 5 proceeding. You have to go back to the FAA and look at contract principles and what this agreement says. And this agreement says that it covers disputes between private parties, and a Section 5 proceeding is a public enforcement proceeding brought by the Commission on behalf of the Commonwealth in the public interest.
No one, from what I hear today, no one is disputing that the MCAD can go forward in its public capacity.
The FAA in this case, in this specific language, doesn't give the court the power to order dual tracks here. It doesn't go that far.
I'm afraid your time is up.
Thank you, Your Honors.
Good morning, Your Honors. My name is Catherine Zeal, and I'm General Counsel for the Massachusetts Commission Against Discrimination.
Is it essentially your position that Warfield is wrong?
Yes, if to the extent that it is being read to bar the Section 5 powers of the Commission to engage in its enforcement activities.
But I'm
Assume
not
it's
sure
not
anybody's arguing that it does.
Well, then it depends upon, and that's how I understand, Your Honor, I understand Joule's counsel to have conceded that. However, just as with the EEOC in the Waffle House case, the court was faced specifically with the issue about whether or not, and this is the Court of Appeals had decided there would be a splitting of the baby, the employee could proceed in arbitration on the specific victim-specific damages, and the EEOC could proceed on the public remedy. The court in that case, the Supreme Court in that case, said no, that's not the way it's going to be. The EEOC, because of its preeminent and important enforcement powers and the responsibility of vindicating the public interest in ending discrimination in employment, should not be impeded in any fashion, nor should complainants or employees be deterred in any way from filing complaints with the EEOC, and is entitled to proceed in an enforcement action in court seeking both remedies. And that is the same argument that we are making here today. Any attempt, and there's been a lot of revisionism with respect to what it is exactly Joule has sought, both in their papers, in the motion to compel, in their papers before the court, and now today in argument, but any attempt by an employer to interfere in any way with the statutory right of an individual to file a complaint and participate in an investigation of a claim of discrimination under Section 5 is against public policy and impermissible as a matter of law.
So can an employee then get two remedies or a double remedy?
No, the employee absolutely is not entitled to two remedies with regard to victim-specific.
Or two recoveries?
No, our position is that once a complaint is filed, that has preeminence over any private agreement between the employer and the employee with respect to...
Why? We have a public policy that favors arbitration in this state.
That's correct. However, there is that public policy that public policy puts arbitration agreements on the same level playing field as other contracts. Under state law in Massachusetts, this court clearly looks at the public policy of that which is subject to the agreement. Here, there's an incredibly strong public policy represented in Chapter 151B. Not only every branch of government has recognized this. The legislature, this court, in Stonehill and other cases, and the Attorney General's office by filing an amicus brief. This public policy outweighs the public policy in enforcing this private arbitration agreement.
Well, Warfield also recognizes the public policy.
Right.
I mean, I'm
That's
not sure
correct.
I don't think there's any disagreement among the parties, certainly here.
It doesn't appear to be.
But if the arbitrator comes back with an award that's higher than the MCAD award, well, how much is Joule or the employer responsible to pay?
Well, in the EEOC case, there had already been an arbitration award, and then the then the EEOC decided to go forward with an enforcement action. Here, the arbitration hasn't begun, and it's the Commission's position that the enforcement action has preeminence, and in fact, this appeals court in the City of Boston case actually addressed the issue of what effect an arbitration agreement, an arbitration decision would have.
So in effect, you're telling employers that they cannot have an arbitration agreement regarding discrimination, that it's meaningless.
Not at all. Of all the cases in which employees and employers resolve their disputes in the arbitration setting, we are aware of three cases only, in which a pending case at the commission, a pending charge of discrimination that was under investigation at the commission, where an employer has attempted to obtain a motion to compel the complainant into arbitration and to, in essence, end her participation in the complaint at the MCAD. There's 3 cases only, but those cases, by the way, are taking up a considerable amount of the resources of the commission, and that's why in the Warfield case, had that issue been addressed, or had that issue been raised, I should say, had the complainant, the employee, filed a charge of discrimination, the employer then gone off and sought to compel her arbitration and to end her participation at the MCAD would have been involved in that case.
So what are you saying that there's either a practical or a legal effect of a stay of arbitration once there is an MCAD action?
I'm not sure I understand.
Does the existence of an MCAD proceeding have the effect of a stay on an arbitration
Absolutely.
proceeding?
And the reason for this is that the MCAD is not only prosecuting a case, but it's enforcing through administrative decision-making. It does a lot more than the EEOC does. And in fact, in Waffle House, Justice Thomas dissented because the EEOC was not rendering administrative decisions for private parties. We do, the MCAD does. The MCAD, if it finds discrimination, must enter cease and desist orders, can enter affirmative relief calculated to end the discriminatory practice, can award civil penalties from $10,000 to $50,000. This is a police power, and it cannot be interfered with.
Could you answer Justice Spina's question? What if the MCAD enters an award and the arbitration award also, both are for the individual in a specific amount of money? Is the employer expected to pay both, higher, lower? Which has collateral? Which has?
Assuming that, and we're saying that shouldn't be the case here, but assuming that there's already an arbitration
You're
award.
saying it won't go forward because there should be a stay.
No,
so that won't happen.
That's right, but I can use your scenario. Assuming that there had been an award, it would not be binding on the MCAD. The City of Boston, the appeals court case, is a prime example as to why. The court said in that case, the appeals court said that the MCAD must take into consideration an arbitration award, but in that case it also said that while the arbitrator had done everything correctly, it was light. The decision was light on discrimination. When the case came to the MCAD, it was investigated. It was a case involving a guard at a prison. It was investigated at the MCAD, and unlike the arbitration decision, which found just cause for the termination of an African-American guard, the MCAD, following investigation, found a pattern and practice of discriminating against African-American individuals, found that the decision-maker, the superintendent, was motivated by bias and had made very stereotypical and racist decision-making. So the commission found in favor of the individual complainant, finding discriminatory acts had occurred, whereas in the arbitration proceeding where that investigation never occurred.
Well, I take it your position is not that arbitration agreements are invalid, just that the MCAD takes priority should they choose to
That's
proceed.
absolutely correct.
And secondly, that certainly the individual, if the arbitration agreements are valid, can't remove the case under Section 9 and bring their own action in Superior Court.
That's correct as well.
Why, could I just ask you, why can't these go on parallel tracks? In other words, if you have an arbitration agreement, and assuming it's a valid one, and the MCAD is proceeding, why is it that the MCAD should go first?
Well, the MCAD is proceeding pursuant to its police powers, and
Right.
and so I think just based on that, it takes priority. But additionally, as the EEOC, as the Supreme Court pointed out in the Waffle House case, anything that deters an individual from exercising his or her statutory right to file a discrimination complaint, and that is a statutory right under 151B as well as under Title VII, and interferes with that right, cannot be countenanced and is against public policy. And having a complainant participate in 2 forums at the same time is exactly that kind of deterrence. The MCAD relies on complainants filing complaints. That is just the way the legislature created the statute, the way the legislature established the mode for the MCAD to become aware of discrimination in the first place, and then to allocate the scarce public resources that it has towards vindicating the public's interest in eliminating discrimination in employment.
But I'm confused now, because let's assume an employee brings an action against a very bad employer and decides to proceed under Section 9. The MCAD may say this is a very bad employer, and we want to maintain our investigation to pursue our remedies, correct?
That's correct.
So there are two forums then?
Well, there's, first of all, I think there's a major difference between a proceeding under Section 9 and proceeding in the private, confidential arbitral forum. Under Section 9, the court controls the case and and it's a very different situation. It has the safeguards that are necessary. However, it is true that the MCAD could choose to initiate a complaint and, in the public interest, continue and proceed on that matter. And in fact, there's some statutory authority for even, as well as regulatory authority for even barring a complainant from going forward in court, an issue not raised today, but under Section 9. So I'm not sure if I answered your question.
We'll have to leave it there, Ms. Seal.
Oh.
Thank you.
Thank you.